We're going to transition a little bit over from some of the issues that Annette brought up with regards to functionalities in graphical user interfaces with our first speaker of the second panel here. At the end of the two speakers' discussion on inherency and functionality, then we're going to turn it over to Q&A. So we'll deal with all of them in one kind of large Q&A at the end. So our first speaker in the second group is Uma Suthersanen. She is a professor at Queen Mary, University of London. And she's an editor of Sweet and Maxwell's European Copyright and Design Reports. And today she's going to talk about, her talk is titled Designs, an Affair Between Function and Aestheticism.
Thank you very much for that introduction, and thank you also to Mark and Graham for inviting me to this event. I have 20 minutes, so I can't spend too much time thanking everyone. And I've been told to cut the speech. So this was supposed to be part, and it is part of a larger socio-legal reflective piece on exactly what design is, not just in design law, but also in copyright law. So some of the things may not make sense because it's part of a larger piece. I've just cut and pasted a bit here to talk basically about design law. Okay. And the paper itself, the wider paper, basically asks why we discriminate against designs, why there is a discrimination between fashion designs, industrial designs, mass manufactured sculptures, and that was in reference to the Star Wars case, garments, fashion accessories, and products which basically marry aesthetic and functionality and which appeal to the consumer. Not that we actually know which bit of the product appeals to the consumer. Another way of looking at that query was, why is it that design law is so caught up with this whole question of function and aesthetics? And why is there a discriminatory attitude towards three-dimensional products? Because there is a discriminatory attitude, not just within design law, but also within national copyright laws, Italian copyright law, German copyright law, and, of course, British copyright law. And why there is an equation which says function is the opposite of aesthetics, especially because I have very deep concerns about the word aesthetics. I do not know what it means, and I've been looking at this for about 4 years now, and I am overwhelmed and quite in awe of tribunals that say they know what aestheticism means when I don't. So go. As I said, this is part of a larger piece as well, which actually looks at hybrid rights like design, and I do compare it a bit with database right in the larger piece. Ooh. But let's go straight to it. First of all, the nature of a design. And the first part was about positive meanings, in the sense, can we actually define it in a positive way rather than defining it as what it is not? Etymology. I went back to try and trace where the word design came from, and apparently, according to 2 or 3 dictionaries, it is an amalgamation of the Latin term and the French term, meaning to indicate, to designate, to mark out. Tried to go back behind the Latin term itself, and I could only find one source, which is the Dictionnaire étymologique de la langue latine. And that went back and basically hinted that it comes from sino scenare, which goes back to Sanskrit suvati, meaning to permit, to grant. So putting all of it together, it seems the history is to permit or to grant someone to designate or to mark out. This sort of makes sense because it is very close sometimes to trademark law. It is close, of course, to copyright law because it indicates or designates who the creator is. And then there's design law, but I'll come to that in a minute. Since we were in Oxford, I looked at the Oxford English dictionary definition, and there are 5, and I only picked 3, but there are 5 different sort of nuanced definitions. One is it's a plan, it's a scheme, it's a project. The other is it is an idea as executed, i.e. the expression of an idea. This is an artistic device, a pattern. The last one I found most interesting. Design is the action or art of planning or creating in accordance with appropriate functional or aesthetic criteria. It is a selection and arrangement, it's almost like selection, arrangement, combination, of artistic or functional elements making up a work of art, a machine, or other object. In other words, even the definers within the Oxford English Dictionary came up with the same dilemma that you see within the Berne Convention, the Paris Convention, and the TRIPS Convention, Agreement, which is it can be a work of art, it can be a machine, it can be something else. It is an industrial product, it is an artistic work. Why make the distinction? If the dictionary definers don't. Let's go to designers. Designers have lots of definitions. Some call it problem solving. It's all the white bits, yeah? Others calling it a preparation of instructions for the production of manufactured goods. The design is an idea. Victor Papanek, who is very interesting for anyone interested in design, because he has rather weird ideas about what a design is, says it's a conscious and intuitive effort to impose meaningful order. There was the International Council of Societies for Industrial Design when they gave evidence to the Australian Law Reform Commission, which grappled with the same question for several pages, I think a whole chapter, as to what a design was. And basically, it's about formal properties and determining form properties. I like the last one most, though, by Gomery, who says it's really a commercial impetus within the invention product consumer cycle. And I tend to believe that's what it is today. Maybe it wasn't before today, maybe 300 years ago it was a different area, but today it is very much about the consumer and what makes the consumer buy. For example, if you go to any that's John Lewis, which is a large, for those who don't know, a large department store in lots of cities in England. And they consciously sell furniture. I'm sorry, but this is not really designer furniture. If you take away all the colors, that sort of cupboards, my grandmother used to have those in the 50s. But they actually put it under the design collection. They've got the designer there. If you can see, there's a little pen there with his face and his bio. And it's sold to us as art. Similarly, if you go to the Dyson bit, which I've got, you know, the Dyson new air multipliers. They call air multipliers, but they're actually fans and heaters. They're fascinating, by the way. If you go to the display cabinet within John Lewis, it is displayed as a work of art. They are in glass cabinets, just as if I was in a museum. And what I said was commercial organizers do use design to sell very functional products. Creators may actually put beauty and function together. It's not true. It's not clear how they do it. But consumers appreciate well-designed and functional products. They appreciate it, but you don't really know at what point they're appreciating what. I'll come to what I mean in a minute. When we go to two decisions which I have problems with, and now this is the EU Community Design Law, which when it first came into being, based on the Max Planck's paper, was very much of the view that it should be for what designers say design is, which is a symbiosis, function, and art. And it was also very much, and if I'm not mistaken, based on the Max Planck view, that we should actually forget the patent approach, the copyright approach, the artistic approach, the industrial approach, and go for what it is, which is the marketing role. And the very first, the attempts at drafting the definition were very clear. It's about marketing. And you can see in the Green Paper, they considered a very holistic concept when they discussed it in 1991, the Green Paper. And they agreed. Designs and symbiosis have three elements. It's function, aesthetics, and it's the investment put to marry the two and put it out to the marketplace. And we're not going to spend a lot of time discussing this. However, they thought that perhaps it was too wide, so they anchored it to appearance. And the reason they said appearance was because they were trespassing into the world of ideas and inventions. Fine. But I can still live with appearance. So that is what it finally turned out to be. And this is what it is today. Design means the appearance of a product. The rest is inclusive. So it's just examples. But basically, it's the appearance of a product. Sorry. Yes. Yeah. Sorry. So if you look at that particular clause, three things appear quite clearly. One, it doesn't talk about aestheticism. It doesn't talk about artistry. It doesn't say it has to be pretty, attractive, have eye appeal. You don't have to have industrial character or industrial application. In fact, the article that defines products as any industrial or handicraft item, it is quite clear that we're not going to do anything with the definition, the subject matter, to bring this old debate back about art versus function. Now, there's the negative meaning whereby a subject matter of intellectual property protection is defined, is contoured, both by the positive definition and as well as what is excluded. What is excluded under the CDR? well, to three types, but I've only put two. The third is morality. But the one I want to concentrate on is features which are solely dictated by its technical function. There, features solely dictated by technical function. And this was to deal with this whole, preoccupation that we mustn't let designs be protected, which would better be protected under patent law. Nevertheless, it's not that clear because there are three possible ways to define it. Now, the first one is a theoretical perspective. Well, that means it's an academic perspective. Is there a technical function being achieved? Yes. If so, is it solely dictated by the technical function? Apparently, there are two further ways to interpret solely dictated by technical function. One is the old British approach in Amphersis Utilux, whereby you don't actually look at the technical function and ask yourself, is that the only shape that will produce a technical function? No, it's a lot wider. Basically, in Amphersis Utilux, they said, in deciding whether a design is dictated by functional considerations, look at the designer's motivation, ask yourself whether every feature of the shape is attributable to, caused by, or prompted by the product's function. Now, that's a lot wider than the next test, which was the multiplicity of forms test. And that test, sorry, I have to go back, is you look at the technical function, and it's a very simple question: can you achieve that function by any other shape? If the designer has a choice of two or more shapes and can achieve the same function, well, basically it's not solely dictated by function, looking at the word solely. That last approach was the traditional OHIM approach, and is, as far as I can tell, but anyone who knows more recent case law, as far as I can tell, is the current approach in all the EU member states, which is when you look at solely dictated by function, you look at the shape. Can we do this by any other shape? Yes, of course. Well, then it's not dictated by function. The reasoning, of course, came from a previous case, which was the Advocate General Colomer in Remington, Phillips and Remington. It wasn't a trademark case at all. Sorry, it wasn't a design case at all. It was a trademark case. But in order to basically distinguish between the different types of functionality in trademark law as compared to design law, telling us, really, a functional design is eligible unless you can show the function can never be achieved by any other different form. So that was how it was, and I was happy. Then these two decisions came. And then the unhappiness arose. Basically, it was the Board of Appeal in 2009, but most recently, it has got reaffirmed again by the invalidity division in 2012. And in Limner, this is what they said. And every line is important. The first line I could have lived with. As long as functionality is not the only relevant factor, the design is in principle eligible for protection. Fine, it's vague, but I can live with it. It's the second sentence. It is only when aesthetic considerations are completely irrelevant that the features of the design are solely dictated by the need to achieve a technical solution. It must be stressed, that sentence, this is not tantamount to introducing a requirement of aesthetic merit. Fourth sentence, better still. It is simply a recognition of the obvious fact that when aesthetics are totally irrelevant in the sense that no one cares whether the product looks good, bad, ugly, or pretty, and all that matters is that the product functions well, there is nothing to protect under the law. How do you actually prove to the court that I care it looks bad? No, really. Because, what they're trying to say with the two paragraphs is aesthetic consideration is not the same as aesthetic merit. I do understand that. We're not going to go into whether it's good, it's pretty, etc. But what are aesthetic considerations, really? How is it different from bringing in a whole discussion, as the last paragraph shows, it looks pretty, it looks ugly, and it, basically the 2012 decision of the invalidity division repeats the thing and says CDR protection is denied to designs not because they lack aesthetic merit, but because aesthetic considerations play no part in the development of the design. We could have, well, I just had this example, which I know I'm supposed to go over very fast, but it's just that this sort of, patents and design patents filed in 1969, taking aesthetic considerations and is very difficult. The Olivetti typewriters only became cool in the 80s. Same for every product. The visual appearance takes time. Spectators, consumers, everyone in the marketplace takes time to actually think about the visual and aesthetics, especially if a new product came in. I go back to the Dyson fans. When I first saw them, I wasn't actually struck by how lovely they look. They do look lovely. I was actually struck. I kept putting my hand inside going, oh, look, it's cool. You know, I was really struck by how they managed to get the fan without blades. And it took me about 30 minutes before I went to the visuals. Moreover, I'm not sure Lindner can say that because you have recital 10. And recital 10, the first part, yes, we know. It says innovation should not be hampered by giving protection to technical functions. Features with technical functions. But the last line, this does not entail that a design must have an aesthetic quality. So now we have two words, aesthetic considerations, which is the two tribunals, and recital 10, which says do not look at aesthetic quality. This could have rested there, except I was a bit surprised this summer, the new manual on the examination of design and validity applications within OHIM. And they changed it this summer to take into account Lindner and all the other decisions, saying Article 8 CDR denies protection to those features, etc., that were chosen, as opposed to features that were chosen for the purpose of enhancing the product's visual appearance. So the examiners now, in order to look at the functionality of the product, in order to see whether or not it is dictated solely by function, have to also check whether these features were chosen, I'm not sure by whom, but presumably the designer, for the purpose of enhancing the product's visual appearance. Which is, by the way, wrong according to the Lindner Board of Appeal, because the Lindner Board of Appeal, if you remember, said you have to look whether the product is ugly, bad, pretty, nice to consumers. So their notion of aesthetic considerations was a lot larger than enhancing it. And few. So I'm going to race through the next. The basic point I wanted to make here was why functionality, which does define the nature of a design, should go back again to the notion of enhancement. Look, it's not just visual appearance, it's enhancement in the manual for the examiners. It is about aesthetic considerations or aesthetic quality, as the recital tells us not to take into account. And all these things, the only question I ask is, in practice, how will you prove it to the court? Whose perspective will you, I mean, if you're going to ask the designer's perspective, of course he's going to say yes, to get protection. I mean, you know, are you going to ask the consumer? And you have to look at the consumer. I cannot see how you cannot look at the consumer. Even artists, and that's what I wanted to just finish, you know, even artists like Marcel Duchamp, who takes ready-made products, even he admits as an artist, you know, that you have to look at the spectator. And that's the other part of the paper, which you won't be getting. But basically, it is that the only way you can tell aestheticism, it's just a two-way communication. The designer makes it, but whether or not it's visually appealing, whether it visually takes in the marketplace, whether it's visually significant, whether it works, is the marketplace, the spectator, as Marcel Duchamp talks about. And I think that is the only problem that's going to come up from the OHIM decisions. Thank you.